All right, Eddie. Thank you so much, sir, for always being our MC and getting everyone excited about this weekly Wednesday webinar, as you stated, 3 p.m. edition. And today is one of those special days, actually. Eddie, you failed to mention that today is going to be one of those special days because not only do we have one webinar, but we also have another one at 6 p.m. So there's going to be two webinars today. And we are so thankful that we have so many of our members coming in and potential members as well joining us on this great topic that we have. Before we get started, it's just something that I wanted to mention and leave it out there for you to think about. And I know it's probably one of the reasons why we have so many people in attendance. And that is because October is actually National Estate Planning Awareness Month. So if estate planning is something that you've been thinking about and then just need a little push to get it going, you came to the right place this afternoon. So again, thank you all for being here with us. As always, I'm going to go ahead and introduce our panel. But before I do that, we always love to see participation from our attendees. So we ask you to please use the chat and the Q&A feature to submit your question, comments, any suggestions, anything that you want to share with us. We'll be more than happy to read your questions. And as always, the commitment is that we will answer every question before we let you go this afternoon. In charge of keeping track of the chat is none other than Miss Andrea Londono from the marketing department. She's going to be reading all your questions towards the end. Also assisting Andrea this afternoon is also Eddie Villanueva, our official MC. You already heard his voice. And the person that is in charge of putting all this beautiful content for us, as always, Miss Carrie Lazar, who is always amazing, and we thank her for everything that she does for the weekly Wednesday webinar team. And as Eddie mentioned, we have not one but two special guests this afternoon. A familiar face, you've seen him in many of our webinars, and that is Michael Schimmel from Fellows Financials. He's going to be here with us this afternoon. But presenting this time for the first time, we have a new face, and we're so excited to welcome him. His name is Ruben Devia. He is a certified financial planner with Fellows. He has a little over a decade of experience in this particular field. One of the quotes that he's known for, and I really like it, he likes to say, "Money does not come with instructions." Money doesn't come with instruction. That is one of Ruben's favorite quotes. And you will get to see why once we get diving into this presentation. A little more background about Ruben. He comes from the wonderful country of Peru in South America. I'm pretty sure he's a big fan of ceviche. We love that here too.
Absolutely.
He, he moved into the DC area about 20 years ago. He's a local graduate. He's a local fellow patriot. He got his degree from George Mason University. And so we are so excited for Ruben to go ahead and lead this presentation with us this afternoon. So Ruben, the floor is yours, sir. And thank you so much for being with us this afternoon.
Absolutely. Thank you, Milton. Thank you, Eddie, for having me. So let's get started. It's a pleasure to be here, and we're going to be talking about estate planning because, as mentioned previously, it is National Estate Planning Awareness Month. So estate planning is not just for people nearing retirement or those with complicated situations. It's a very important part of your overall financial plan because it can have a major impact on who inherits your assets and who you want to control the process of handling your assets when you die. So today we're going to cover what an estate is, why you might want to consider setting up a trust, what different types of trusts are, how they fit into your plan. And we hope you'll come away with a good foundation on what you should consider when thinking about your estate. So what is an estate? What exactly is it? Almost everyone, whether single or married, has an estate. It includes all of your property, and that can be, real estate, your home, investment properties, personal property as well, such as cars, furniture, antiques, coins, art, whatever you may have that's of value. Intangible property, it's also a big one. That can be your bank accounts, your check-ins, your CDs, investment accounts, stocks, bonds, maybe some life insurance policies or loans that you made to other people. All of these things are what we consider intangible property. Moving on, a good place to start, I guess, when we are having a conversation about estate planning is to understand how your assets are owned and whether you want to consider possibly changing that. Assets that are jointly owned with rights of survivorship, that just means that the ownership can be transferred to heirs rather quickly. In this situation, when one of the owners of an asset dies, then the other owner immediately becomes the new owner. This is typically how married couples own their assets. If something happens to me, then the assets are just become my wife's. That's what it means to jointly own something. Different states might have different rules. As community property in California, it's tenants by the entirety here, or it just kind of depends, but it's the same idea. Uh, Another type of ownership involves naming a beneficiary. So when you have a named beneficiary, assets can move to your heirs quickly and conveniently, kind of like jointly owned assets. Some examples of this type of ownership are, beneficiary designations on life insurance policies, IRAs, and annuity contracts. The third major type of ownership is, individually owned assets, when you solely own them. These are the ones you just own by yourself. They have no rights of survivorship, nor do they have a beneficiary designation, which makes this category can be a little bit complicated when determining who will inherit the assets when you die. If you have completed a will, which we're going to touch on a little bit later, then the laws of your state, don't really apply much. But if you have not completed a will, then the state, basically the government, will determine how your assets be passed down to others, and who's going to pay the expenses and things relating to your estate. So let's move on a little bit more to the distribution of assets. As we noted earlier, everyone has an estate. So it's not just for people with large amounts of money or many types of assets. It's literally just anybody that has property. So most people that I've met want to be able to control their assets, how they're distributed when they die. So to ensure that your wishes are followed, you need to provide, clear instructions that state who you want to receive some or all of your assets, what you want them to receive, and even when they may receive it. And of course, having all this happen while paying the lowest amount of taxes, very few legal costs, and hopefully no court fees. So, simply speaking, estate planning is deciding how and to whom you want your assets distributed when you die. So that begs the question a little bit. Why should you pursue estate planning? Kind of like I hinted earlier, because if you don't, then the government will dictate how your assets will be distributed. Most states might not be a big deal. Then if you're married and have children, your spouse and children could each receive a share of your estate. Your spouse may receive a portion, and the probate court might control, the inheritance of minor children. Just given these issues, it's just better to have it in place so that you are the one in charge. You are the one that's handling your assets. Your wishes are going to be followed, and by you or by a family member, but not by a court. You control how who receives the assets and when they receive those assets. So we've been talking about assets, so we need to identify the assets too. It's a little bit surprising sometimes when I meet with new people, when I meet with some clients, how many individuals just don't know what they have, or they have things lying around, or old plans that are not there. You essentially want to get started. You want to prepare an inventory of your bank accounts, your investments, your retirement accounts, whether they're 401ks with current or former employers, your IRAs, your real estate, your businesses if you have one. You also need to, identify what are those valuable assets. That it could be a very expensive ring that your husband got you, or it could be a nice guitar collection that's worth many thousands. Once you identify those assets, and then you'll need to decide, how are those assets to be distributed. For example, my wife will probably get most of my things, but my brother's getting the sports car, right? And then my children are getting some of my collectibles. It's just up to you. It's up to the individual. But having completed this step, let's just talk a little bit more now about some key elements of an estate plan. Let's start with powers of attorney, probably something that you may have heard before, but a power of attorney is a document where you give someone the power to make decisions on your behalf. And let me just give you an example. If something were to happen to me right now, then my wife Ruth could sign checks for me on my behalf, make necessary decisions regarding my assets, my children. In fact, actually, I could go back home after this presentation to a big sold sign outside my house. Hopefully, it doesn't happen, but that's the type of power that she has because she has a power of attorney on me. Uh, that being said, there are a few different types of powers of attorney. General powers of attorney grant broad powers, but cease if something happens to you. Whereas springing powers of attorney are quite the opposite. The power is granted when you become incapacitated. Then there's durable powers of attorney that kind of encompass both. They're like always there. They're durable for a reason. And I just want to add a little quick side note, just being a financial planner and working with clients. It's important to let your bank, your financial planners know if someone has power of attorney and share the documents as necessary. I actually recall a time where a client's daughter called me asking to distribute some of her father's money and that she had powers of attorney, which was true. She did have it, but I hadn't been notified. So I had to do my due diligence, check with my client, and make sure everything was actually in order. Which it was, like I said, but this is a big step because God forbid you're in a bad situation, you're not able to make those decisions. Kind of the last thing you want is for the person you've given trust to have to be doing paperwork. So make sure if you do have one of these in place, make sure the appropriate parties know. Let's move on to what's called a living will. Many of us have probably prepared one of these already. They go by many names, such as advanced medical directives, healthcare proxy, medical power of attorney, even. But a living will is a statement often available as pre-printed form with wording approved by the estate in which you live of your wishes regarding things like life-sustaining treatment or medical interventions that you may or may not want in the event that you become unable to communicate or even terminally ill. Your living will also specifies who you want to serve as your healthcare advocate and who has access to your medical records. So it's an important document to have. Choosing that person obviously is very important. You'll want to be certain that he or she can understand treatment options concerning your condition, deal with the stress of making difficult decisions. That's actually quite a biggie. And keep in mind your best interests and your wishes when making these choices, right? Just a quick example. In my case, my wife makes most of the calls, unless it comes down to who's going to pull the plug. Then I want my dad making that decision, and that's a true story. But let's move on to a will, and we're going to spend a little bit of time here because wills are very important. What is a will? Well, it's a legal document that specifies how your assets are to be handled after your death. It allows you to name a guardian for any children who are dependent on you. Guardianship is a very important part of the estate planning process. I have 4 small children myself, so one of the toughest decisions was determining who was going to be that person. It also names an executor, who is the person who will be in control of your estate once you eventually passed. So if you have a written will, you are essentially making your intentions explicitly clear. If you die without having a will, then that's called dying intestate. You have no control over who receives your assets. Your property will still be distributed. Just the probate court will appoint someone as the administrator of your estate. and then that person will be responsible for distributing the assets in accordance with the appropriate laws. As a general rule, most state laws give your property to people closely related to you, as I mentioned before, by blood, marriage, or adoption. If you don't have any children, or if your relatives can be located, then the government kind of just takes your property. It's generally not a good idea to die intestate. In most states, two witnesses must kind of sign your will, just kind of to avoid forgeries, and that just indicates that people actually witnessed you signing your wills. So what are the kinds of wills that are commonly used today? The most common is what's known as the simple will. It simply specifies the distribution of your entire estate to your beneficiaries. There's also, a testamentary trust is a document that will establish one or more trusts that will then receive portions of your estate upon death. A pour-over will is another type of will, often found with trust, where it places your estate into a trust that is set up before your death. And we'll touch on trusts in a little bit here. An unwitnessed will, if you handwrote it, it's called a holographic will. I'm not entirely sure why. I definitely did not come up with that name, but they are considered valid in some states, and Virginia here is one of them. An oral will is one that isn't written, and only a few states in the country actually permit these. Virginia is not really one of them, except for very limited and specific circumstances. But for all matters and purposes, I'm just going to say that is not a thing you should be doing in Virginia. Lastly, a joint will is just two wills containing one. This is typically what husband and wives do. So let's move on a little bit to another aspect of it. I mentioned the executor, who is the person who manages the estate. He or she can do just about anything that is required to handle the administration of the estate. This includes resolving claims made against you by other people or businesses, paying debts, paying taxes, which is never a fun one, paying out assets to the beneficiaries named in the will. So it's a person with basically a lot of power. Some states allow the naming of an independent executor who takes an inventory of the estate's assets and files it with the probate court. He or she is then free to distribute the estate without involvement by the court. The court could, of course, always become involved if someone challenges the will, or if they challenge how the independent executor is handling the estate. Yeah, one thing we'll notice between wills and trusts is that wills can be challenged, and that can be a little bit of a disadvantage, but it's still better not. Should you appoint as your executor? And that's a very personal decision that only you can make. I mean, most people appoint their spouse, that's or the person who is the primary beneficiary of the estate. That's because that person is likely to ensure that the probate process is moving efficiently and with low expenses, right? Because if it's your spouse, they don't want your assets to just get spent. If they're the one that's going to be receiving the money, they're not going to want, external parties to get a big chunk of it. Also, it's a good idea to name a successor executor in case the first one dies or is otherwise unable to take on the duties of the executor, right? This is also true of beneficiaries if you have in your accounts. Yeah, just make sure that there's always a secondary person. Same with powers of attorneys or medical directives. Always make sure you've got a backup, right? I think this wraps it up for wills. So now let's take a look at the role played by trusts in estate planning. What is a trust? Well, it's a legal and financial arrangement that is used to hold and manage property and assets. When you put property in a trust, you are transferring from your own personal ownership to the ownership of the trust, which then holds the property for your benefit or for the benefit of some other person that you listed. It is generally necessary and advised that you have an attorney create your trust documents. There are two broad categories of trust: revocable and irrevocable. A revocable trust, as the name implies, can be modified or rescinded during your lifetime. In an irrevocable trust, the terms and conditions are generally just cannot be changed once it's been created. So I'm going to move on to some types of trust. Two common types of trust are testamentary trust and living trust. A testamentary trust is a form of irrevocable trust which comes into existence after your death. It is created in your will or in your living trust and exists for as long as that document requires. For example, for the spouse's lifetime or for a specific number of years. Uh, One kind of testamentary trust is the bypass trust. Perhaps some of you have heard about this. This allows the family to save on estate taxes, but by funding this trust with up to a particular dollar amount prescribed by federal law, which kind of changes every year. This is known as the lifetime exemption. Currently, it's 15 million per individual. The bypass trust can then provide income to your spouse, but the spouse doesn't have full control, and that's one of the items with bypass trust. A similar testamentary trust is the marital power of appointment trust. Try saying that quickly. In which money is put into the trust for the spouse to invest or for other financial management uses. Here, the spouse does have control of the assets and can decide the final beneficiaries. So who eventually gets the assets after that spouse passes. A third kind of testamentary trust is known as a Q-tip. I'm sure someone will ask what it means at some point or what it stands for. But these types of trusts are usually set up to benefit like the spouse of a second marriage when you have children from a first. So, which is a fairly common occurrence. Essentially, what you want to protect against is that your spouse receives income while your spouse is alive, but any remaining assets then get passed down to the children from your first marriage, right? Last thing we kind of want is somebody that kind of takes your assets and disenfranchises your children because they're not their children. I'm not saying it would happen, but let's just kind of protect against it. So, moving on, let's talk about living trusts, which are established while you're still alive and are very common. So we're going to look at those in a little bit of detail. This is probably the most common type of revocable trust is the revocable living trust. This allows the person that creates the trust to make changes or revoke the trust during his or her lifetime. There's usually three parties to a living trust: the creator of the trust, which is known as the grantor, the trustee. This is the person who manages the trust property for the creator and for the beneficiaries, and usually one or more beneficiaries to the trust. In a living trust, you are the grantor, typically, since you would, and likely you're going to want to appoint yourself as trustee also, which at this point means you retain control of all the assets, how it's handled. So for all matters and purposes, it might not be under your name, but you do have total control of whatever you put in this trust. Unlike a will, a living trust can avoid probate when you die. This is why a lot of people get it. It does control your property and assets and prevents courts from managing them, right? If you become incapacitated. So how does this happen? Because with a living trust, you no longer actually own anything. Your trust owns everything. So there is nothing for a court to control when you die or become incapacitated. As I mentioned, you will likely appoint yourself as trustee of your living trust, and you should also appoint a successor trustee or trustees who will handle the trust when you cannot. Remember that if you have a living trust, you likely still need a will, most likely a pour-over will, which will then gather any assets you may have forgotten to put into your trust and place them in your living trust. Let's, there's always pros and cons with everything. So let's maybe talk about a little bit about the advantages of establishing a trust, a living trust. One of them is it's going to be peace of mind, right? You know that things are being taken care of properly, and sometimes that's a good enough reason. But depending on the type of trust, it could help lower or avoid estate taxes. If you've got a large estate, depending on how the trust is written and on state law, The assets in the trust may be protected from creditors. A trust, like I said, generally avoids probate so that a court is not involved and so that you have maximum privacy regarding your assets and how you want them to be distributed. With a will, or if you don't have a will, everything kind of becomes public knowledge. With a trust, it actually just completely avoids that. Um, another thing is that, if you do get a living trust, then all of your property and assets are under a single plan. So it kind of makes it easy to manage kind of rather efficiently too. Additionally, a revocable trust can be changed or canceled at any time by you, right? Also, makes for quicker distributions of assets to your beneficiaries once you do pass. What about the disadvantages? There's always two sides to each coin. So there are a few drawbacks with trusts. First is that, like I've been mentioning, you do need to transfer all of the assets covered by the trust document into the trust. You might, for example, have to have a new deed for your home, or have to retitle your joint bank account or your joint investment account. We can help clients with that quite a bit. And it is a process. It does take some paperwork. You would also need to keep separate any transactions involving the trust and those involving property or assets owned in your name, right? So if there's a difference that for whatever reason you don't want in your trust, it's just more bookkeeping. Whenever you buy or receive an asset that you don't want being involved in probate, then you need to, either buy it in the name of the trust or make sure you transfer it to the trust. Creating a trust isn't particularly expensive, though it'll cost you, probably several $1,000s, especially if an attorney is involved, which is always a good idea. A trust certainly costs more than a will, which people can do online rather quickly. But even though it might seem costly to establish a trust, remember that your estate will save money when you die because probate will be avoided. There's probably going to be fewer fees and costs associated with it. And since it will eventually come from your own money, it usually makes sense to kind of just go ahead with it. You will kind of need to pay close attention to the laws of the state you live in. You might be required to pay a transfer fee to move some of your assets into the trust. Could be no issue depending where you live. Could be a slight nuisance, but it is a thing to kind of be aware of. As you can imagine, since there's multiple parties involved, especially after you die, the trustee and the beneficiary, for example, they could disagree on who's managing the assets, how are they going to be invested. Maybe they want it at some company versus the other. Maybe they don't like your financial planner. Maybe they do. So that could create some tension. I always say it's a good idea to have a sit-down conversation with all the parties involved, just so they know your wishes. And in the case if you work with a professional, maybe introduce the beneficiaries to that professional so they're kind of aware of how everything fits in place. Yeah, I think that kind of does it for trust. So we can probably talk for longer, but let's just kind of go over the essentials. So we've talked about asset ownership, wills, trust, powers of attorney, and living wills or medical directives. So to put all this into practical terms, let's review the key steps in estate planning. Best starting point is to identify all of your property and assets. Like I said, make an inventory and estimate the current value of each one. Then think about how you want your assets to be distributed after you die. You need to think about who should get what property and in what amount and when. Another step that many people forget is to actually check your beneficiary designations that are already in place. And sadly, I see this a lot too. For example, you probably have several benefit plans with your employer that have provisions for beneficiaries, such as group life insurance, 401ks, pensions. Make sure your beneficiaries are up to date. If you have a trust, make sure the trust is the beneficiary when appropriate. Also look for beneficiary designations on your life insurance policies outside of any employee benefit plan. A lot of people don't even look at those. I heard a horror story of a client who got remarried, didn't change his life insurance beneficiary, so the ex-wife ended up getting close to $1 million. I'm sure she was happy about it, but I can't imagine that and family was too content. So always good to keep this up to date. Um, Consider changing how certain assets are owned. For example, you might have investments for which you could add payable on death to your beneficiary's name, right? You could do this with bank accounts, right? So that it can completely avoid probate. You can do this with investments too. Uh, Take some time to learn about, estate taxes, which, like I said, there's a high lifetime exemption of 15 million, but if you're in a situation that they know that it's a 40% rate, and that some individual states in the country might have also taxes associated with it, you probably need want to consult a financial advisor about estate taxes, since they can be complicated and change relatively often. I mean, here at Fellows, Michael Shimon and I, we're well versed on taxes and how they relate to estate planning. So it's always an integral part of what we do. Now let's I guess bring it back full circle. I think it's worth mentioning again some of the major elements you might want to consider as you get further into estate planning. You should consider arranging for your estate planning documents, power of attorney, particularly for financial matters, in case you become unable to communicate or are otherwise disabled. Having living wills, medical directives, or whatever name you want to use, helpful to your family and doctors, since it specifies the level of care you wish to receive when medical issues leave you unable to make your desires known. It also ensures that your wishes are clear and takes the burden off your family in making very difficult medical decisions that they might just not want to. You certainly should have a will, so that distribution of your assets after your death is handled in the way you want, and a will will make it clear to everyone exactly how your estate should be distributed to your beneficiaries. And lastly, you might want to consider establishing a trust. I would say especially so if you've got maybe a blended household, or it's a second marriage, or you've got many moving pieces. I would say consider that with a little bit more urgency, perhaps. As we have seen, there's many types of trust, and each kind is designed to handle a specific situation. I'll obviously consult an attorney and your financial planner when it comes time to create the type of trust you think is most appropriate to you, and obviously kind of how to fund it, to make sure stuff is on it. I've had funny scenarios where people get trust and then they don't put anything on it, and so at that point, why get it? But I think that wraps up what I kind of wanted to share with all of you. I appreciate your time and attention during the presentation, and hopefully it wasn't too technical, but enough to kind of get you to know some of the information, get you to consider things for estate planning, and maybe even a little push to not put off thinking about estate planning any longer. A lot of people just don't do that. My sister-in-law recently got married, and I talked to them about having their documents updated, and they're saying, we'll get around to it eventually. I'm like, let's kind of get on it sooner rather than later. Whenever there's a life event, if there's a new child, grandchild, if you just got married, got divorced, you bought a business, any large transition you're going through in life, probably a good time to at least review your documents to see if a change is warranted or not. But yeah, I guess I'll leave it at that, and I guess I'll be happy to answer any questions now.
Awesome. Thank you so much, Ruben. That was an amazing presentation. We truly appreciate you sharing all your knowledge with us here this afternoon. And again, officially welcome to the Weekly Wednesday family team here. We're so happy to have
Thank
you
you.
with us. I'm not going to go too much into my spiel, because I know that I see a lot of questions, a lot of comments on the chat. So I'm going to hand it straight over to Andrea and Eddie for all those questions that we got that we got on the chat and the Q&A. So Andrea and Eddie, the floor is yours.
Thank you so much. So the first question that we have is, if I have a few CDs, can I add them to my trust, and how do I add them?
Yeah, sure. CDs, bank accounts, investments, any of those type of intangible assets, which is what we call them, you can transfer ownership to a trust. It depends on what it is and the institution. They might have some paperwork to retitle it, or they might just ask you to set up an account in the name of a trust and then just kind of transfer your individually owned assets to that account. Should be straightforward to do. Just the paperwork might vary per institution.
And thank you so much. And the second question is, do you offer power of attorney forms and notaries?
We personally do not. Here at Fellows, we are we're financial planners first. We are very well versed you know in the estate planning uh, subject, but you will want to probably consult with an attorney, get those put in place when it's time to retitle assets or add a power of attorney to one of your accounts. Then we can certainly help you with that. But we will not physically draft your documents and have you sign them. An attorney should do that. Yes.
And we have, is a will or trust better when leaving your child a house?
That's kind of like the million-dollar question. I would kind of say that a trust is probably cleaner. A will can be contested. Not sure about your specific situation, but if you've got two children and you leave it to one of them in your will, then the other one might contest it. Trusts are generally, not contestable. So if you expect some hesitancy, maybe a trust would be better. Um, I guess at the end of the day, having a trust does make it simpler, and there's some fewer risks just by having those in place. So either will do, but I would probably say at least consider a trust given your specific circumstances.
Thank you. And this is a question for Carrie. Will the presentation be sent to the attendees?
Yeah, I can email the slides today, and then next week we should be good with the recording on our YouTube channel, but I'll mail the slides if people want them. I'll send it right after.
Thank you so much, Carrie. And the next question is, should I do an estate plan even if my mortgage is not paid off?
I would say yes. I would say if you haven't done an estate plan, then you should definitely have it done. Yeah, I sometimes compare it to driving without a seatbelt. It's okay if you don't get in a car crash. You don't need the seatbelt, but if you do, then I really hope you had one on. So estate plan it's kind of like that. You should have it done. If you haven't paid off your mortgage, it's okay. I mean, the property is still under your name. Someone's still gonna inherit that if you pass. So whether your kids get a house with a mortgage or without a mortgage, then it's what I want to be clear is who's gonna get the house what percentage if you're going to split the ownership. So you should definitely do your estate planning even if you still have a mortgage on your house. Yes.
The next question is an IRA with listed beneficiaries. Does this go through probate or does it need to be listed in a will?
Fantastic question. Yes. An IRA with beneficiaries will completely avoid probate. It is not affected by the will. So if the will says the assets go to your I don't know, child A, but your IRA designation says it goes to child B or to a spouse, then that always takes priority. So whatever the beneficiary designation says, that's what's going to come first.
And we have, wait, when using estate planning, will taxes have to be paid on the inherited items?
Typically, no, up to a limit, right? You can generally pass down $15 million worth of assets to someone that's not your spouse. If it's your spouse, I guess it's always you don't actually have to pay the tax. But if you're going to pass it down to your children or to a neighbor or to your friend, then as long as it doesn't go over that lifetime exemption, there's going to be no estate taxes. So once you get to higher amounts, then you will pay a 40% tax on everything above that. But that's a larger conversation if you're in that situation.
Next question is, can you have two people designated to make a decision in a living will, for example, giving two children equal power?
Yes, but it can be slightly problematic, because what if they don't agree? If your living will says check with my children whether they should do such and such treatment and they can't agree, then typically you might want to appoint a tiebreaker or give someone decision to kind of a little bit more power than the other because ultimately you want stuff to get done, right? You don't want gridlock when it comes to should we perform heart surgery or not. So yeah, you can list many trustees, many people that are responsible for making those decisions. And like I said, a sit down conversation with your family and parties involved is always a good idea, just to kind of avoid conflicts when you can't be there to arbitrate.
Um, as a DC resident, where is the best place to get a durable power of attorney? Does the credit union offer one?
Can't answer for the credit union. Typically, I would say, just there should be estate planning attorneys in the area. Um, that's probably your best place to go to. If you don't have anyone that you have heard of, or we can always kind of recommend one. There's many professionals that we use in the area. Some are specialized on businesses, some on estate planning, some on different things. But the attorney is going to be the person to kind of do it for you. You could technically do them online if you wanted to get those documents, epicwill.com or websites like that. I would say, those are templates and it's better than nothing, but I would say it's probably worth spending a few $100s to get your wills, medical directors, and powers of attorney done professionally.
Next question. For ownership of assistant is if there are named beneficiaries or on individual or joint owned assets, when then does not have to go through probate, correct?
That's correct. Named beneficiaries is probably the best way to do it. For example, if you have an investment account and then your brother is the named beneficiary, the second you pass, it just becomes your brother's. No one has to see a court. It doesn't matter what the will says. If it wasn't in the trust, it's going to supersede it. So yeah, having named beneficiaries, whether it's a savings account, an investment account, life insurance, that just supersedes it completely.
What are the advantages of having a will versus trust?
The advantages of having a will versus a trust. Well, a will is cheaper, right? It's kind of cheaper to do. That's probably the I would say that's probably the main advantage. A trust will often do a lot of things you want to specify in your will. It's just kind of more expensive. You do need to hire an attorney. It's probably 10 times the cost. But if you don't have a totally complicated situation, or if you are not in a position to spend, thousands of dollars drafting up a trust, then a will is it's going to be sufficient and it's going to be good.
Thank you so much. And should you pay off your mortgage or not to be able, wait, or not to be able to take off loans against it? I can't talk, sorry.
Yeah, whether to pay off your mortgage or not, well, that's kind of like a separate financial plan and discussion. But as it relates to estate planning, typically if you have a mortgage and it's under your name, and then you transfer the property to a trust, then the mortgage kind of has to get refinanced. So that might be a consideration to have as far as kind of how to title your home and do you put it in the trust or not? Do you maybe just have a pour over will so that that property goes into the trust because you don't want to go through that pain? It has some intricacies, but I'll just say it depends for that one. Yeah, let me know if you want me to clarify that one. It's nuanced. Let's put it that way.
Next question is, should you wait to refinance a mortgage prior to establishing a trust?
This is kind of piggybacks on the previous one. Since typically you have to refinance your mortgage whenever you're transferring transferring your home to a trust, it might kind of be the kind of the right time to do it. You probably want to establish the trust first because you can't, put things under a trust if the trust doesn't exist. So yeah, it's get a trust. If you're going to refinance your mortgage, make sure everything's done in the name of the trust, and then you can kind of just split it there.
Um, can you talk more about how to set up a trust? Is this something that USFCU can help with?
Um, Well, again, probably one speak for the credit union. I'm gonna guess that they'll probably just recommend going to an attorney. You do usually have to go to an attorney to set up a trust. It has to be an estate planning attorney that knows what they're doing. You want to have a meeting with them, explain your wishes, what you want to happen, who you want to be in charge, and they'll usually draft it up for you, and then send you a draft for you to review. Typically, what I do for my clients when they're drafting trusts, ask them to give me a copy so that I can kind of review it and make sure they understand what it says. Because sometimes attorneys speak attorney lingo, and I kind of have to translate that into non-attorney lingo. So kind of happy to do that for my clients. And then from then on, you give the green light, you sign it, and then the trust becomes an actual entity, right? And at that point, things like the credit union or here at Fellows, we can help you with your investments to make sure there's appropriate titling of your accounts, and beneficiary designations are in accordance of what your trust wants. So yeah, estate planning it usually involves many people, and which is kind of why we're setting up this amazing webinar here to kind of shed some light on it.
And the next question is, what do you place in a revocable trust?
Yeah, you can place basically anything that you want to not go through probate. A lot of people usually place their homes. They usually place a lot of their investments. But you can put your cars there if you've got any expensive art. You can make sure the trust owns it too. And like I said, for a revocable trust, it's done with your social security number. You're usually the trustee, so it's kind of like going from your right pocket to your left pocket. Like it's still on you. You still have full control over it. It's just if something does happen to you, it's going to simplify things quite a lot.
What is the cost of probate based on?
That might depend. Sometimes it's a percentage of your assets, depending on who you use as an attorney. That answer is going to vary based on kind of who's kind of handling your probate. There's some court costs, so depending on your county, your state, it might be more or less. It's and depending on the size of your state, it might be a lot, it might be little. That's one of the considerations that sometimes we look at. Is it better off to get paid $3,000 for a trust, or would it potentially just cost someone, $200 to handle your estate? So it's a consideration, but the answer is going to vary based on where you are, who you're working with, right, and how many assets you have when you died.
Thank you so much. And our next question is, if you have any, or if you have added primary beneficiaries slash contingent beneficiaries via bank, credit card, or credit unions, federal credit union accounts, etc., do we have to add them to a living slash revocable trust?
Yeah, I'll say it kind of depends, right? I mean, if you have an individually owned account, like my bank account has beneficiaries, so if something happens to me, it goes directly to my wife. If, for example, if but you could say, hey, I don't want to own it, I want the trust to own it, then I guess you don't need beneficiaries there anymore because then the trust never die unless you dissolve it. And so once the trust is there, then if something does happen to you, then whatever the trust says will happen, then will happen. I would probably say have if you don't have a trust, at least have listed beneficiaries on all your accounts.
Thank you. And should a declaration of trust be filled in public records after a trust is funded?
Would a declaration of trust be what, sorry?
Filed, sorry.
Uh, Probably not a bad idea. I'm not actually I'm not exactly sure if you have to, but typically your attorney should kind of know, how to make it known that you do have a trust. Yeah.
Should you add your adult kid to your mortgage to prevent pre or probate?
Should you add your adult kid to your mortgage for what was the
Probate.
last bit, Andrew?
Probate.
Um, so when you kind of add someone to a mortgage, if you're like a co-signer, essentially what that does is it's gonna make them responsible for mortgage payments if you can't pay them. I will say the bigger kind of probably not many people would probably allow that, but or want that to happen. But what you actually want to think about doing is name your child as co-owner of a property. That's kind of where it becomes more relevant as far as what happens to your house if something happens to you. If you have a joint owner, then and you don't have a trust, then whoever was the joint owner in your house then inherits that house. The mortgage gets kind of worked out on the back end, right? But the more important thing to focus on is who owns the home and who's going to get the home when you die. Is that going to be via joint ownership, via deed on death, via putting the home in a trust, and then the mortgage just kind of typically follows.
Thank you. And the next question is, can you describe one more time the negative side with respect to state law for living trust?
The negative side of state laws for living trusts. Um, like I said, not a lot. It's a lot better than having a will. People cannot contest it. There could be, someone might contest that the trust is fraudulent, that that's not the original document, and that that the beneficiary has changed it, or that the trustee is not respecting it, that it's not carrying out the wishes of the trust. So in that sense, the court could get involved, right? If I appoint my brother as trustee and the trust says that my kids are going to get the money, 10% for the next 10 years, and then he just takes it and buys himself a car, and then presumably somebody else could take it to the courts and be like, hey, this trustee is violating the trust, and there could potentially be a lawsuit, right? That's, I guess, kind of always the case. There's always a little bit of an issue. The point is that the risk is a lot smaller than just having a will or not having anything in place at all. But it's very very kind of few disadvantages as far as the law goes. Um, but different states might kind of do it differently. And they might be the arbiters of how to deal with conflicts, right? But in general, a lot of the disadvantages of a trust are going to be more on the financial side, how to set it up, some of the logistics, how do you put assets in the trust, some of the kind of like I said, some of the internal conflicts, like what if the trustee and the beneficiaries after you die are bickering about what to do with the assets. So some of those are kind of things that could be avoided with a sit down conversation or just by having a good bookkeeping of your assets. Great question though. Let me know if you want me to explain that a little further or a little clearer.
Next question is, if transfer on death forms have been filled out for all accounts, will my wife have immediate access to those accounts and funds?
Yeah, immediate in as far as how quick the paper intakes, right? Like for example here, if I have an account and if something happens to me, then yes, my wife would have immediate access, but technically just to log it on the system, I'm sure there's going to be some paper that needs to be signed. You submit a death certificate saying my spouse passed. I'm a named beneficiary, so I'm going to go ahead and inherit this, and they usually should make it happen within a day or two. So it does make it very, very smooth. You don't have to record and say that you are who you say you are, and yada yada, and that can take months and months and months. I've seen some estates take years. I've got some clients that are still kind of dealing with it after about a year and a half. So having named beneficiaries just completely bypasses it. It's just the paperwork timing at that point. Great question.
Thank you. And the next question is, sorry about my dog. Is the main difference between a will and a living trust the ability to reduce or eliminate estate tax? Any other key differences when deciding between a will and a living trust?
Yeah, so on the topic of estate taxes, like I said, the lifetime exclusion is kind of enorm is exemption is enormous. It's 15 million for individuals, 30 million for married couples. So if you do kind of exceed that, what a trust sometimes does is if you create an irrevocable trust, you get it out of your estate. Like you put stocks and bonds in an irrevocable trust, then that can grow to infinity, it can grow to 100 million. But since it's no longer under your name, then you don't have to pay estate taxes on that. Neither do your beneficiaries. Doesn't quite work as well with a revocable trust because you still retain ownership. You still file taxes with your own social. So a little bit of a little tax difference there. What was the second part of the question? Andrea, there was something on wills.
Yeah. Any other key differences when deciding between a will and a living trust?
No, I mean, I will just say that just to reiterate that a trust is just more robust, right? It covers your weak spots a lot more. And the main issue is going to be the cost and whether it's kind of necessary. But it's technically you typically want both. Like I said, in case you do forget to put something in the trust, you kind of want a will that kind of says, hey, put everything I forgot about into the trust, right? And then kind of let that happen.
Our next question is, why do we need to add people to a trust if they're added as a beneficiary to our bank slash federal credit unions slash CD accounts?
Sure. Well, I mean, I guess you don't. Why some people get trust sometimes, it's what I call managing from the grave, right? Say, I've got a son, he's not even trying to get a job, so he's not very responsible. He's only 3. But say he were 18, and if I just leave him money, via my will as a beneficiary, he could just go take it and buy a bunch of Pokemon cards, right? And there's no strings attached. Whereas if I put it on a trust, I can say, okay, so my son has access to this. If he gets sick, if he needs it for education, if there's an emergency, or he can access, I don't know, just making it up, 7% each year, and between now and the time he is, 40. So that way I can have control. I know he's not gonna, it's called a spendthrift provision. It kind of makes it so that he just doesn't go, spend all my hard-earned money and just blow his inheritance, like kind of like the prodigal son in the Bible. And that's kind of when you want to set up. Well, it's not when you want to. It's one of the benefits of a trust is that you actually can control how that money gets spent, like long after you're gone. If you don't care because you're like, hey, I'm gonna be dead anyway, so who cares? If that's your attitude, then I guess you don't really need a trust. But but most people do want to control it to some degree.
Thank you so much. And our next question is, do you say all assets put in a trust will remove you as the owner of those assets?
Yes and no. Again, the owner of the assets will be the trust. It will be a trust, and if you name yourself trustee, then you will have full control over those assets, right? So, in principle, like I said, it's taking it from your right pocket to your left pocket. Sure, they're not under your name, but it's in a trust that you control. So there will basically be no difference between what you can do with those assets, right? So, but technically, they are not in your name anymore.
And who do we talk to at USFCU to transfer CDs to a trust? Like phone number, do we have a phone number? Anything?
I don't know.
I would recommend talking to Madison Love, and I can share her info, but she's our IRA manager. She's done a lot of our webinars. She's very knowledgeable. Everybody loves her. I could share her our IRA email address, they could help.
Yes, and I also like to add as well to piggyback on Carrie's answer. And then we encourage everyone to reach out directly to Ruben or Michael Schimmel to schedule an appointment. I mean, I know there's been a lot of great questions coming through, but if you want a more of a personal personal one-on-one with either Ruben or Michael, we have their phone number. You see it on the screen, the 713-779-9750. Or you can shoot in an email, fas@ussfcu.org. Or better yet, if you want to schedule it online, just go to our website, ussfcu.org/financial, well, FAS, I'm sorry. And then you'll be able to go in directly into the calendars and schedule an appointment to speak with them on a personal level. So that is something that we will highly recommend as well. But again, this has been a lot of great questions. Ruben, you've been amazing. We still got more questions there in the on the Andrea.
Yes, we do. But I do want to add that we do partner with um Love My Credit Union, and our members do get a discount because one of their things that they offer is trust and will. So if you go on our website and go to the resources tab, and then you'll find Love My Credit Union rewards. And if you're a member with us, you just go to the Trust and Will link, and then you'll find all the information. I could put the link in the chat. Hold on. Um,
Ruben, I have a question. Does an executor or a beneficiary ever have to give consent?
Well, kind of yes. Well, te technically, you can write whoever you want to be your executor of your will per se, and if they don't want to do it, they said, oh, "Okay, thanks, I don't want it." They do have the right to not be that person. So, like I said, have a sit down conversation. Like, if it's gonna be hopefully your spouse consents to it, but if it's gonna be like a family member or a friend, make sure they know. And definitely have a backup. Kind of like I said. As far as beneficiaries. I have never, I guess, met someone who didn't want to be the beneficiary of an asset. It's like, hey, I'm gonna give you, $1 million if I die. It's like, I don't want it. I don't want it. But technically, they could say they don't want it.
Because, like, say you got a piece of property that was condemned and in another state and just
True.
left to you, and you really don't want anything to do with
Yeah, that's true. They could actually say no. Yes, yes. They don't have to consent for you to write them down, but you can't force someone to have property, right? So if they technically don't want it because it's just a nightmare, or you left them property they just don't want to deal with, then they could say no. Who's next in line? And it would probably go to your contingent beneficiary or whoever's listed on your trust as who would be next.
Thank you.
okay, thank you so much for that question. It's a great question, Carrie. And thanks for the answer, Ruben. So our next question is, do you need an attorney to make a will?
You technically don't. I mean, you could just kind of, like I said, do a holographic will where you just kind of write out the things you want to happen, and that's technically valid as long as some people see it. You could go to LegalZoom or Epic Will or any of the online will companies, and those are valid too, as long as they're properly signed and you might want to get them filed. So you don't need an attorney per se. I would just say if it's your property, if it's a lot, if it's complicated, then it probably pays dividends just to make sure everything's written properly.
Um, are free forms legal?
Are free forms legal? What's a free form?
Could that be a letter of instruction? Not sure.
Um, I'm not sure. Letters of instruction. I guess that's a broad term. We use letters of instruction for many things here at work, as far as what we want to happen, but I'm not entirely sure the context in which we're asking. So shoot me an email, and I'm kind of happy to get back to you on that one. Just maybe it's just different words that we're using for things, but
So letter of intent, letter of instruction was what I meant. I'm not sure what the member meant.
Yeah. I mean, yeah. I mean, those things are legal. Do they carry as much power as a will per se? You know, it could probably be contested if you just write on a napkin, hey, I really want, this to pass down to my neighbor, and then that's your letter of intent, and that's kind of what you want. Your neighbor could technically take it to the court when they're reading your will and say, "Hey, I know the will says that, but my neighbor actually wrote this, and then I have the paper to prove it." Could lead to a bit of a nightmare. It's avoided if it's in a trust, but yeah, if we're talking about the same thing, then technically, yeah, it can have some weight, can lead to some, to a contest in court. But good question. Happy to do more research too, if that's not what you meant.
What are your rates? Is there a discount for members?
Are my rates? Well, as you know, so like I said, we're not attorneys, so we don't write documents and we don't charge for that. At the same time, we kind of review them all the time. Me and Michael are always happy to kind of have, yeah, complimentary consultations. So if you just kind of want us to review some of your documents, make sure everything's in place, let's just kind of have a sit down meeting. We really won't charge you just for like a uh, just for like a sit down as far as how we get paid, when we do manage things like investments and things like that. That's typically how we get paid. But great question. Yeah. Let's talk more if to see if that's what you had in mind. But yeah.
So do you need a loan refi to move your home loan to a trust?
Typically, yes. Yeah, that is one of those kind of annoying things with a trust is that you typically need to refinance your loan. Yeah.
I have a beneficiary for my bank accounts. Is the, sorry, is it still necessary to add a bank account to in a trust?
Um, Again, back to the example with my son, right? If you just want the beneficiary to own the assets outright, then you don't need to. It's going to avoid probate. It's going to be a direct transfer. If you want to control how that's going to be spent, put conditions on it, then you might want to put it in a trust.
Do you pay more taxes on assets that are in a will versus in a trust?
So when it comes to, I guess, dying per se, um, then the estate tax only gets assessed on amounts over 15 million, right? So taxes should technically not really be a factor for most people out there. Um, yeah, state taxes just won't come into play unless you have huge estates. Things like IRAs and 401ks, when the money comes out, the tax is charged at an income tax rate, right? So there is where you could see that. Irrevocable trusts, if the assets are there, that they do have their own tax brackets, and depending on your situation, could be more or less than kind of what individuals have. So there are some tax considerations there, but kind of just depends on the situation, and kind of like how Andrea mentioned, kind of one-on-one conversations are very helpful, because instead of speaking broadly like I'm doing right now, I can get to know you and then be like, all right, given what you're telling me, this is kind of how it's going to play out, and it makes for a little bit more cohesive advice.
Also, thank you so much. And then also going back to the free form questions, um, the member asked, I meant, are the free form wills legal?
Free form wills, um, like you mean like forms you get online to kind of do them per se?
I think that's what they
Yeah.
meant.
That sounds right.
Yeah.
Yeah. If you get any of those templates, yeah, they're legal. Again, especially here in Virginia, any type of writing that you do, as long as it's done properly, can be respected by a court. If it's already like a and honestly, that's what some attorneys do. If it's pretty straightforward, they can have their own templates too. So yeah, as long as there's nothing that's an illegal thing that's going on within the thing, or anything fraudulent, then they should be legal. Yes.
Thank you so much. And how many times can you alter a trust? Is there an associated cost with amending a trust?
Yeah, no, great question. Yes, so trust can be restated, reinstated, or amended, and this often happens kind of how you would want to get a new will when your life situations change. Typically, attorneys will charge you a smaller fee than what they charge you for putting a whole trust together. But if you just make small amendments, or say your successor trustee died, so you need a new successor trustee because those are usually cheaper costs. Again, it will depend on the attorney, so I don't want to speak for them. But yeah, as long as it's revocable, then you can amend them anytime that you want. If they're irrevocable trusts, it's kind of a lot tougher, right? But for living trusts, while you're still alive, yeah, you kind of have full control and discretion on how often you want to change the trust.
Thank you so much. And our next question is, are you adverse to establishing a revocable trust through legalzoom.com?
No, I would say, a trust. Well, I would say if you're talking wills, medical directives, powers of attorneys, I would say doing that is better than not doing it at all, right? And if it's straightforward, then do that. For a trust, presumably, if your will is not enough, that you need to consider a trust. And if there are some online services that can help you with that, that's kind of where I would urge you to actually sit down with an attorney, just because once you die, that trust becomes irrevocable, and whatever is written, then will be kind of like that forever. So I really want to make sure that you know what it says. If you're like if you like the law, and you are studying to be an attorney but never took your bar, and you kind of know what it says and you're comfortable with it, then one could argue that maybe it's fine. But for your average person, I would say if you're gonna put together a trust, actually sit down with an attorney.
Thank you. Our next question is, my house is my biggest asset. Should I use a trust or a will?
Um, Again, kind of depends on kind of how you want that house to be processed after you die, right? Who you want to give it to. Is there going to be, you know, in family fighting because of who you named as beneficiary? If it's pretty straightforward, and you're just have one child who's going to get it, and there's no siblings, then a will might be fine, right? If you can, if you're expecting some tension, then it might make more sense, especially for a large asset like that, to not have to drag that into court and have the court settle what the will says because your nephews and your nieces are fighting over it. So again, kind of depends on the situation. A will is probably, fine if it's straightforward. If you want to control more from the grave, or if you want to have additional wishes than just who gets it, like how much are they going to get and when are they going to get it, then trust might make more sense.
And our next question is, I live in Virginia, but my heirs live in New Jersey. Should I have my estate plan drawn up in New Jersey?
I would not. I mean, I'll probably say that you're well. Check with your attorney is probably the better answer. But well, what I would say is kind of yeah. I mean, have it drawn up where you live. Trusts are kind of respected in all 50 states. So trust, which is another difference with wills. Sometimes wills might have a different, more contestations if it's between different parts of the country, whereas trusts are usually just respected all over the country. So that's another possible advantage of having a trust, is that you don't really have to deal with crossing state lines. And is that court going to be the same as kind of my court here? But Yeah, that's I would probably do it where you live because if there's any estate taxes due, it's probably going to be paid in the state that you live in. But do check with your attorney on that one, especially if it's a little bit dicey.
Our next question is, what is the cost of having a will done and who can I contact?
It's gonna vary. If you do it online, could be could be $100, $200. If you go to an attorney, then it might cost you $400 or $500. I mean, many attorneys have different rates. I've worked with quite a few of them. I've got two that I refer a lot of my clients to because I know they do good work and they're not very expensive. It's typically going to be in the mid hundreds for wills, medical directives, and powers of attorney. It tends to be a package deal.
Thank you so much. And our next question is, if there's art that you want to include in a will or trust, can the attorney who prepares the documents recommended to or typically recommend an appraiser, or must you arrange for an appraisal separately ahead of time?
That's a very pinpointed question. But yeah, I mean, if there's art that you want to include in a trust, yeah, if it's like you know. Like you said, very expensive. You probably want it valued, right? At that point, you probably want to insure it too. And I'm sure attorneys work with appraisers. I'm sure they can refer you to someone. I personally wouldn't know kind of who to refer you to kind of do that with your art. If you have the Mona Lisa in your closet, I'm not sure who can value that one. But but I'm sure the attorneys know how because they deal with a lot of people that and they've seen a lot more colorful things than I have. I'm sure I can run the question by them if it's like an if it's your actual case and you actually want an answer for this. I'm more than happy to check with my go-to attorneys and see if they've got any names for you. Just kind of shoot me some contact info and I can go ahead and kind of or I can just ask him myself and give you the answer.
And thank you so much again, Ruben, for answering all the questions and saying a little extra. I mean, normally, these webinars don't run this long, but as you can see, this has been a very important topic, and our members do have a lot of questions. So again, what we would encourage everyone to do is, if you wanna know more, if you wanna ask Ruben more on a personal level, please reach out to him. His contact information it's on the screen right now. And we also are going to be sharing a copy of this presentation as well with everything that Ruben covered today. I think that Andrea, and I know normally we say that we have a commitment that we will answer every question live, but we are coming a little about 30 minutes over the time that we had planned for. So we can go ahead and take two more questions and then we'll go ahead and wrap it up. And also because we need to get ready for the second webinar that we have coming up at 6 p.m. In regards to the government shutdown and what is the credit union doing to those that are impacted by the government shutdown. So, Andrea, if we can squeeze in two more questions. And again, Ruben, thank you so much for staying a little over with us here. We truly appreciate you.
Of course, happy to be here.
Yep. Our next question is, can a trust protect your assets from bankruptcy, IRS, or hospital bills?
Yes. So one reason people tend to get trust is that you do have extra protection from creditors. And that's very helpful, especially if you set up, some form of irrevocable trust and you get things fully out of your estate. Then it can definitely protect against that. Kind of how you set it up. It's again, I guess the devil's in the details, but that is a type of protection that comes sometimes with some forms of trust that wills necessarily wouldn't do because a will might just they're just gonna come after you in court anyways. Well, not after you because you'll be I guess underground, but after your executors or kind of the people in charge. Yes, the answer is yes. It can protect against creditors. Yes.
Are there
That's one, Andrea. Make it a good one.
So the last question is, are there disadvantages to living revocable trust even if you name yourself as a trustee, and can it be undone if needed?
Well, given that it can be undone, I would say, aside from the cost, and maybe who to pick as successor trustees or how to handle the beneficiaries, I wouldn't really say there's any strong disadvantages, right? If for some reason you just hate it, then you just terminate the trust. You're in full control. So no disadvantages that can be solved. Cool.
Excellent. Thank you so much again, Ruben. We truly appreciate you coming in. This was a nice intro to the Weekly Wednesday family team, and we very much look forward to having you back and coming in and hosting more presentations here with us. As you can see, we have a very dedicated and very much of a great audience here on the Weekly Wednesday webinars, and providing your expertise, something that we truly appreciate. And it goes with it does not go unnoticed. So thank you again for your time and your flexibility and staying a little over with us here this afternoon. With that being said, I'm going to hand it right over to Eddie to do the closing remarks and invite everyone to our webinar at 6 p.m. And Mr. Villanueva, if you don't mind doing the honors for us, sir.
All right. Thank you, everybody, for joining us this afternoon. Ruben, fantastic answers. Thank you very much for sharing your expertise. I learned something new today, that if you want to manage things for the grave, you got to get a trust, So I love that term. I'm going to definitely keep that one with me and put it in my pocket and run with it. So thank you so much for doing that. Thank you to the attendees that stay, this long with us. This webinar was very helpful, very insightful, a lot of great information. And as we were, emphasizing earlier, if you have those specific questions, if you want to have that one-on-one conversation, please, message Ruben. He can tailor a plan for you, whether you want to do investments, whether you want to prepare for the future, or you want to do some, short-term goals as well. He's the person that you want to talk to. So, and then just to emphasize that for our, USFCU members, if you are a member and you want to have a, consultation with Ruben, it's free for you to do that as well, So please make sure that you take advantage of these products and services that we have here at the credit union, and everything is confidential. Whatever you talk to between you and Ruben, it stays between you two. He doesn't share any information with the credit union. We want to make sure that you're mindful, of that, and that we make, confidentiality a top priority. And then with that being said, as Milton was saying, we have another webinar at 6 p.m. in regards to it, the government shutdown relief program. There's some rocky times in Capitol Hill. So if you want to join us at 6 p.m. and learn about how the United States Senate Federal Credit Union, it's here through the good times and the bad times. We want to make sure that, join and tune in. And then next week, please put this under your calendars. Next week, the United States Senate Federal Credit Union, we're celebrating our 80 years of existence since 1935. I don't think Ruben or Milton or Andrea or Carol or myself, we were not around in 1935, but best believe that whatever happened in 1935 with those Senate staffers that started the credit union, the same movement is happening in 2025, which is, making sure that, the Capitol Hill staff and any of our members, even outside of Capitol Hill, they can reach their financial goals and dreams. So we have a solution for you. Please join us next Wednesday at 6 p.m. And then also, like I said, we have a webinar this evening at 6 p.m. as well. With that being said, without a specific order, Carrie, Andrea, Milton, and Ruben, thank you so much for, everything that you did today for this team and then for this webinar. And most important, thank you to all attendees that attended, this 3 p.m. Version of the Weekly Wednesday webinars. With that being said, hope everybody has a great and blessed day, and we'll expect you at 6 p.m. today and next week as well. Take care, everybody.